By the end of this video, you will know 3 contracts that online creators must know about, and not just what those contracts are, but some key terms and the problems that they will prevent. So let's dive in. First is terms of use. And terms of use are a contract between you and users of your platform, your community, your app, your site. They tend to be kind of long, so it's hard to pinpoint just 2 or 3 key terms, but some of those key terms are prohibited conduct, and that can include a code of conduct for membership sites, grounds or rights to terminate a user's account, so reasons why you might terminate somebody's account, limitation of liability, and maybe an affiliates policy. Problems that the terms of use can prevent, well, it can help you to manage conflict with your users, with your audience. If something goes awry, you have immediate recourse according to your terms of use. And of course, there's that CYA, to cover yourself if something goes wrong, limiting your liability if someone gets hurt or doesn't follow your instructions properly, or their business is hurt, or they suffer monetary damages, or at least they say they do because of some of the content that you've put out there. The terms of use can limit the liability, your liability, and limit the money that someone can actually go after to the extent it's allowed under the law. Overall, terms of use require your users to agree to the terms of use before using your site or your platform, and if they don't agree, then bye-bye. Next is a contractor agreement, and that is an agreement between you and any contractor that you use, whether it's a photographer, a copywriter, a graphic designer, a social media marketer, that lays out the terms of your relationship with that individual. A lot of times contractors will have their own service agreement that they will send to you, but you would be surprised how many people don't have contracts. So you might need to have your own contractor template on hand. Common terms. IP ownership. This is key because of that copyright myth that you've heard me talk about before. People think that because they've paid a contractor to create something that they own it, but that is not true, right? Under US copyright law, any copyright transfer has to be in writing in order to be valid if it's not done by an employee kind of in the course of their job. So having that IP language in a contractor agreement, crucial if you want to make sure that you own that intellectual property. Non-solicitation is another thing to think about having in a contractor agreement. It's a little bit different from non-compete, and it depends on state law, but it basically prohibits a contractor from soliciting either coworkers or other contracts away from you, or your clients or customers away from you for a certain period of time. So that's a little boost in protection. And then there's use of your systems and confidential information. So if a contractor needs access to your passwords or, login social media accounts, devices, confidential information like analytics data, all of those things, kind of having something in a contractor agreement that spells out how to handle confidential information and what happens if that confidential information is misused. Problems that a contractor agreement will help you avoid, essentially peace of mind. Peace of mind when it comes to knowing that your IP ownership is secure, peace of mind when it comes to treatment and use of your confidential information and systems, peace of mind when it comes to knowing that your relationships with your customers are safe, all of those things, and of course having a document that has it all laid out so that you and the contractor have a mutual understanding in one spot as to what's going on. The last document is a collaboration contract, and that's different from a sponsorship or kind of an influencer sponsorship agreement. It's almost like a styled shoot in the event planning world. where maybe you collaborate with another business in connection with a launch, an event, something like that, where you are both promoting something together, like a joint promotion arrangement. Common terms. Well, you have roles. You want to make clear who's doing what. There is ownership of intellectual property, so who owns the photographs, any web pages, any copy, any posts. There's use of any IP, so who can use it and for how long after the campaign or after the venture has ended. And then there's confidential information. So again, to the extent you need to exchange confidential information to move this thing forward, whether it's analytics information, your target market information, information that you'd use in connection with any Google or social media ads, how each of you must treat the other's confidential information. Problems that this type of document would avoid. Avoids discrepancies on who's doing what, kind of makes sure everyone's on the same page there, and avoid mistreatment or misuse of IP. Maybe you've decided that if you create something, each of you create something, you own whatever you've individually created. That's fine. But just making sure that those things are clear and put in the document so that everyone's on the same page. So you've got your terms of use, you've got your contractor agreement, and you've got your collaboration agreement. And I hope this video has helped you understand why these documents are important, how they come into play, and the problems that they might help you avoid. And if you like what you saw here, you have an online business, I've got a little treat for you. Sign up and you will learn 4 things that you can do right now to protect your business online. Just go to spear-ip.com/challenge. Thanks, I'll see you next time.